Thank you. It's a privilege to present this case to you all, and thank you for allowing me to do so. I'll get right into the facts. The facts are as follows. Beth Burns, the plaintiff, was the winningest women's basketball coach in San Diego State University's history. And one day in 2013, she walks into the athletic director's office thinking she's walking into an annual review, and she is unceremoniously told that she has three choices. She can resign immediately, retire, or she can be fired and put her retirement benefits in jeopardy. Why, you might ask? Well, the accusation was she was accused of assaulting an assistant coach, which happens to have been on video since these games are fairly popular. And later, she was accused of being demeaning to her subordinates. She was told that this activity was confirmed by the university in an independent internal investigation. So under the threat of losing everything she had worked for her entire career, she was about 58 years old at the time, this head coach chose to resign. The investigation ultimately was revealed to be a sham. The assault allegation was revealed to be pretextual for the firing. Beth Burns went looking for her own champions, and she found them in Ed Chapin and Goddard. The investigation was proven to have reflected inaccurate wording of interviews, and Ed and Allie went to try to find out why San Diego State University would treat such a winning coach and such an asset to the university in this way. And what they found out was, well, Coach Burns, she demanded equality for her team. She demanded equality under Title IX for her women's basketball program. And she was successful in her crime, where she wanted parity in equipment quality. She wanted parity in practice facilities. She wanted season passes to be sold. Ironically, her contract called for her to get a bonus on percentage of season passes sold, and she couldn't get them to even offer them. She wanted parking passes, adequate coaching staff, everything that Title IX provided or called for, and she did not get it. And they just didn't want to deal with her anymore. Why? Because her demands would require them to divert precious funds from the very successful, well-known men's basketball team, and they just didn't want to do it. So Ed and Allie worked tirelessly, putting in thousands and thousands of hours and over $500,000 to get the case through trial. After a 5-week trial, the jury determined that Coach Burns was, yes, that the San Diego State University had violated the California Whistleblower Act, and that Coach Burns was entitled to $3.36 million, which I might say for a single employment case is a tremendous verdict. It represented 47 times the differential in what she was earning at San Diego State and what she was earning at the time of trial as an assistant coach at another university. It also included millions of dollars for past and future non-economic damages for this now 60-year-old or 61-year-old assistant coach. So not only did Ed and Allie convince the jury, which included 2 former San Diego State University students and 1 current grad student, that San Diego State had wronged Coach Burns, but also the judge, who was quoted on the record as saying, it was like San Diego State, for a pretextual reason, just tossed her out like a squeezed lemon. And I can assure you that was not the judge's impression when the case started. So, in fact, it wasn't the defendant's impression either, because the highest offer before trial was $5,000. Okay? So, anyway. In addition to the verdict, Ed and Allie were granted $1.9 million in attorney's fees. I'll talk about some obstacles, a few. San Diego State is a very well-respected university in San Diego. It's actually a pride. The sports teams there, the system is very much part of the San Diego culture, and they have a wonderful reputation. The witnesses included the president of the university, the athletic director, and the much-beloved men's basketball coach, who Ed very deftly got to acknowledge Coach Burns' wonderful qualities rather than focusing on the accusations against her. Second, the incident which Coach Burns was accused of making physical contact or assaulting her underling was on video for everybody to see, and there was contact, and it was subject to varying interpretations, obviously. Thirdly, Allie had to overcome some implicit bias that she experienced from the judge at the beginning of the trial. It was displayed in front of her client, a woman, and the jury, but by the end of the trial, I'm happy to report that the judge recognized that Allie was a fearless and fearsome lawyer to be reckoned with, and she got the respect that she had deserved from the beginning. And lastly, Coach Burns was not really warm and fuzzy and was a quite difficult person to deal with, and it was not easy to get her to be embraced by the jury, but through Ed and Allie's work, obviously the jury embraced her. Let me get to the impacts on California consumers. The verdict sent shockwaves throughout the sports world. It was reported in the national news. I believe Allie went on CNN or somebody, ESPN, somebody did. It was a tremendous result that will help all employment law practitioners get some leverage in negotiating their settlements and mediations, because, like I said, not everybody can expend all of those hours in doing what they had to do to get this result. And I will also say they brought justice to one deserving woman, but really what they did was point out, time's up, guys. We deserve, and this fight for gender equality is going to continue, and guess what? We're starting to win. We're going to continue to win, and if you do not give the women's collegiate sports teams what they're entitled under the law, we are going to hold you accountable. So please recognize Ed and Allie, and I urge you to provide them this award.